And we're now joined by a seasoned election lawyer, Jude. Counsel Jude, thank you so much for making time for us.
Thank you, Raymond.
Yes, we seem to be destined now to the Supreme Court for determining the matter that has come out of a presidential election petition. First of all, are you surprised that this is where we are going with the election?
No, I'm not surprised at all, because frankly, I think the number of contentions that we have had in this election are too many that it would be unfortunate if there was no legal challenge ever raised. We know, for instance, that we had a contention over consultations, whether someone can hold rallies as a form of consultation or not. We know that virtually no candidate who was able to carry out consultations. Then after that, we had all the serious challenges that have been posed by the COVID-19 pandemic and the restrictions, the lockdown restrictions. And we have held an election in the midst of a pandemic. A lot of challenges came up. This is also arguably one of the most violent elections in recent memory. And therefore, I think the ground was very fertile for a legal challenge to the outcome of this presidential election.
You were in the Supreme Court in the last election, and you must have definitely learned some lessons from being in the Supreme Court at that time. What would you tell the National Unity Platform now about the kinds of evidence they need to go to the Supreme Court?
First of all, I think it's very important, and I think it's good that they have made that decision very early and fast enough, because it also influences how they go about preparing their petition. One, they need to look at the winning margin between their candidate, between the president-elect and their candidate, the Honorable Kyagulanyi. They need to be able to ask themselves whether they are going to be able to satisfy the justices of the Supreme Court, and most importantly, I think, the public opinion as well, that this margin could be overcome, but for the irregularities that happened. That means they need to, when there are complaints, for instance, at one polling station has around 400 voters. That's not good enough. You are going to need to demonstrate that the winning margin, which the president-elect has, would be affected by the outcome if the election was conducted differently. That is what they call the quantitative test. In other words, you get into the numbers to demonstrate that the irregularities cost the NAP candidate this number of votes, or that the irregularities led to the disenfranchisement of a high number of people whose will is not reflected in the final outcome, and who probably, if they had voted, would have affected the outcome. For instance, if you demonstrate that over 3.5 million voters were disenfranchised, that would be a very good case to make. That is one area. The other area is, if they don't want to get into the numbers, then they are going to need to demonstrate that the quality of the election was so poor that it shouldn't be called an election as such. In 2016, we made the argument that it should not always be about the numbers, and much as the petition was lost 9-0, the judges also unanimously agreed that an election petition can succeed if the petitioners are able to demonstrate that the quality of the election is so poor. But that is a very, very high standard. As far as I can tell, the number of even parliamentary petitions which have succeeded simply on demonstrating that the quality of the election was poor because of violence and intimidation. One was in 2006, I think, rather 2001. James Garuga Musinguzi and Mama Mbaba, that parliamentary petition. Then I think Abudu Katuntu and the late Chirunda Kivejinja in 2006, they also had that. But the amount of affidavit evidence, for instance, which you require to prove that the quality of the election was so poor, you're going to need affidavits from virtually more than half of the country. That means you need not less than 500 affidavits.
And you need to be working at the moment.
You need to be working, yes. So we had not less, we had around, I don't think we had 80 affidavits in 2016. So if they are going to argue that, there is quite a lot of work that goes into gathering affidavit evidence, and you know, it should be representative of the electorate. So you're able to build a case that, for example, if you show there was violence in just 2 districts, that's not good enough. It must be widespread. You need to be able to demonstrate, whether it's violence or intimidation, that it affected a wide margin of the country.
Counsel Jude, we now see, at least from the pronouncements of the presidential contender, Robert Kyagulanyi, that they intend to challenge mostly the declaration of results, how the results were being declared, and the lack of fairness in the declaration of those results. Is there any evidence to support them in that regard?
It's a bit of a complicated issue, Personally, my personal view is that the manner in which the Electoral Commission has been declaring presidential election results, both in this election and in the person of 2016, is actually in violation of the Presidential Elections Act. Because as far as I'm concerned, Section 56 of the Presidential Elections Act requires that a returning officer in a district is supposed to tally the presidential results of a particular district and transmit them to the Electoral Commission. What that means is that the Electoral Commission is simply supposed to be aggregating results of districts. But now what we see, they claim that they are aggregating results of different polling stations across the country. They don't explain how they do it. For 2 elections in a row, they are deliberately excluding Kampala and Wakiso. I'm using the word deliberately because, frankly, I think it's really not a coincidence anymore. They did it in 2016. They have done it again. So there are serious legal issues on that. There's no doubt. My concern is it's important to also look at the precedents in terms of the judgments from the Supreme Court in 2016, 2006, and 2001. The Supreme Court judgments, the majority in 2016 it was unanimous, 2006 it was 5-4, 2001 it was 3-2. But the majority have always taken the view that, you see, it's not enough to challenge the format of results. You need to show, you need to go into the substance. So, for instance, you cannot simply go and make the case that the manner in which the results were tabulated was violating the law. The justices may actually agree with you that, yes, it's true, it violated the law. Then they will say, but did it affect the outcome
of the result?
That will be the problem. So it's very important that whoever wants to take the path of challenging results, challenging the procedure and all, they need to really get into the substance and try to demonstrate either that the substance is tainted or that the substance would have led to a different result. Otherwise, it may be a slippery slope if they take the approach of simply challenging procedures and how the declarations were made. In 2006, Dr. Besigye's legal team made the same argument, challenging the manner in which the Commission had received the results. As a matter of fact, in 2006, the Electoral Commission received the results from district study centers via phone calls. And
phone text message,
not text messages, phone calls. Phone calls, and they didn't deny it. They insisted. I remember in the affidavit of the Electoral Commission chair, he said we set up a teleconference facility, and the agents of candidates were allowed to listen in as the results were coming in, as we were also listening to them. The judges agreed that was violating the law because it's not provided for. But ultimately, the majority made a ruling that it was not enough to show that the manner of reception of results had violated the law. They needed to demonstrate that the results which were received via that illegal mode were not authentic results. And as long as they didn't demonstrate that, the majority justices took the view that they hadn't made their case.
What I hear you saying a lot is the substantiality test. How substantial is the evidence they have to overturn the result? And I know, as a lawyer with experience, and what kind of evidence do they need now to make a substantial case?
Of course, it's a very delicate issue to sort of get into. But already the Electoral Commission has confessed they didn't tally results of 1,200 polling stations. It would be very useful to get into the tallies of those polling stations. In fact, as far as I'm concerned, the issue is that the Electoral Commission has admitted that they have disenfranchised people in 1,200 polling stations. It would be good to get those numbers. How many people were registered to vote in those polling stations, for instance? And then maybe a case could be made that they have disenfranchised people who voted in those polling stations. And then they get into those numbers. That's very critical. Okay? It's very, very critical to get into those numbers. And if they are going to challenge results, for example, of 1 or 2 or 3 polling stations, yes, you have made the case that there was an irregularity. But the general principle is that there is no perfect election anywhere in the world. And the judges will always happily remind the petitioners that, look, there's no perfect election.
There's also scholars who've argued about the political question doctrine, the fact that the politics of the day must also be taken into account when the Supreme Court petition is being made. Is it something that the lawyers now will have to take into account, that there's the politics of the day which exists?
I think the politics of the day, ultimately, when you decide to take a case to the court, you must have some level of faith. Otherwise, you run into the danger of taking the view that, well, even if I make a good case, it's going to be, I will not succeed. But for me, what I encourage whoever chooses to file a petition, the moment you take the step of filing the petition, it's important that you forget about the politics. The politics is always there. We all know it. It exists everywhere in any case. And once you have made that decision, I think it's very important to realize that a petition ultimately, even if it doesn't succeed, it has some value that it contributes, even to the body politic itself of the country. Some of these petitions would be useful the day we want to think about, for example, reforming the law, maybe in 10, 20 years' time. They give a good indication. For example, one of the reasons why we have secret ballot using only one ballot box at polling stations is because historically, each political party used to have its own ballot box.
Yes.
And that was found to be a very wrong mode of conducting elections. So there are changes that take place. So it's important that once a decision is made to file a petition, it's better to get into the merits and give it your best. Otherwise, there is a danger of allowing political considerations to cloud your ability as a lawyer to prosecute your case very well. So I always discourage lawyers, once you have chosen to file the petition, file it in good faith, prosecute it. Presume that the justices are going to be as impartial and independent as possible. Even if it doesn't happen, that's really, you as a lawyer should do your case. What you have to avoid is giving an excuse to the court of public opinion and to the justices that you have made a very shabby job at your case, okay? Which I think partly affected us in 2016. I think it's good to avoid that approach and try to make the case that the justices have done their part. They may choose to agree or disagree with your case, but still it's important that the case is made as well as it should be made.
Very finally, you've talked about the fact that previous cases have provided basically some body politic to start with. What advantages do the people who are filing a petition now have to benefit from the petitions that have been filed before? What advantages do they have in those petitions?
First of all, for instance, in 2016, we applied for declaration of results forms for the entire country, which had not been done in 2006 and 2001. At the time, actually, the Electoral Commission had declined to avail them. But in 2016, the Supreme Court judges unanimously ordered in a brief ruling, they asked the Electoral Commission to avail us all the DR forms. So right now, I expect that there is no turning back. The Electoral Commission, they should be required to avail all the declaration results forms for the entire country. That should be non-negotiable. If they make that negotiable, then they won't have benefited from the little work we did in 2016. It becomes important. We tried to raise a few questions regarding the usefulness of the biometric voter verification kit. I'm hoping it's another issue that's still out there, needs to be resolved. If we are using a biometric voter verification kit at various polling stations to verify the voters who are voting, then it should be fair to demand for the printouts of each polling station of that biometric voter verification kit to be able to know how many people actually voted and whether those numbers tally with the outcome contained in the DR forms for each polling station. So that is an area where I think there was significant progress, and I'm hoping we'll move forward. Again, in 2016, the Chief Justice and the Justices were kind enough, and they allowed you people in the media to cover the proceedings live throughout. In 2006, it had been rejected. So again, I'm hoping there's no turning back on that, because it's very important. These are not matters involving two individuals, but a significant section of the country is interested in the outcome and needs to know how this process transpires one way or the other.
All right, thank you so much. He's been speaking to Counsel Jude Byamukama. He was a lawyer in 2016 at the presidential election petition, and he's speaking to us about the kinds of evidence that the National Unity Platform, which now says that they will contest the elections in court, needs to have before that can happen. Thank you so much for joining the Fact Checker.